Go ahead, Ms. Douglas.
We would note that the Intoxilizer results were done an hour and 45 minutes after the police encountered Mr. Hopkins. So this crash happened at about 3 a.m. Intoxilizer was taken at 4:48 and 4:53 a.m. And so that's 48 minutes and 53 minutes after the initial interaction. And so that's actually pretty high for it to be almost 2 hours later and the blood alcohol to still be that high. And we'd also note that the report suggests that it was Mr. Hopkins who was at fault and that Mr. Hopkins is alleged to have told police that he thinks he fell asleep while he was driving. So, Your Honor, we do think there's that danger there.
Okay, thank you. And Mr. Bulahanis, did you reach out to the court as far as getting this matter scheduled today?
Yes, I did, Your Honor.
Okay.
We were calling the court every week for 1 year, and for whatever reason, the prosecutor took almost a year to bring this case to the complaint stage. So if they were concerned about Mr. Hopkins, they would have filed this complaint right away. And Mr. Hopkins has nothing to do with how long it took them. That's a normal time to process a client from, 45 minutes from the time it started. That's not abnormal time. And we don't know what Mr. Hopkins' metabolism is. It could have been, he could have been going down or a little bit lower, or it could have been going up from the time he was, arrested. So nobody knows that.
Okay, thank
And
you.
he has 47 years of driving, Your Honor. I mean, not 47, but he's 47 years old. He doesn't have any priors. And he's a CDL driver. So his driving history's got to be good. Otherwise, they would revoke his CDL.
Okay, well, this is from 2024, and certainly the, court, has some concerns as it relates to, what happened at that time. More than a year has passed now, unfortunately.
Your Honor, I would suggest maybe random testing, or, which I think would be more appropriate, or potentially a sober link.
You have any issues with the sober link, Miss Douglas?
Your Honor, we believe just that the alcohol tether would make sure that whatever vehicle Mr. Bell is around, he is not able, or he is not drinking. If he's a CDL driver, we don't know if he's driving all sorts of different vehicles. So we do think that the alcohol tether will be something that would be effective no matter which vehicle he is driving.
Your Honor,
Does he work for a particular company, Mr. Bulahanis?
Yeah, Your Honor, we can get him, we can get a sober link with him probably as early as Monday. I do have a contact with Nationwide Interlock Services, Your Honor. They provide sober links for my clients. I just had one provided yesterday in Ferndale, and they provide these. And as the court's aware, they can set the times, different times during the day that Mr. Hopkins would have to test. And, this would clearly show whether or not he's using alcohol, and he'd be required to blow into it several times a day, 7 days a week.
And what's the earliest that he could get connected to that, to the sober link, Mr. Bulahanis?
If you think it's acceptable, Your Honor, I could, they waited a year to proceed on this case. I could get it
Well, we're not
for
gonna wait a
sure,
year.
a sober link as early as Monday, Your Honor. If it was earlier in the day, I could try to get it today, but I know I can get it on Monday, Your Honor. If we could have until Monday, 2:30, he might be able to get it earlier, but whatever times you set out, he will comply with, Your Honor.
Okay, the court has heard the arguments of the parties. I do understand the concerns of Ms. Douglas. It has been more than a year. He's working, he's retained counsel, and counsel has indicated that there is another way for monitoring alcohol usage. Typically, if he would have come in, then he likely would not have left out had he actually been at the court without something. But Mr. Bulahanis, the Sober Link today is Friday, and you're able to call them today.
I'd be able to call them today, but they wouldn't be, because it's so late in the day, they'd be able to get it for them on Monday for sure.
Within, I'll say 72 hours,
Thank you, Your Honor.
be connected to SoberLink. And gonna have to provide some proof of that to the,
We can, yeah, we can, the representative from SoberLink will provide that to the court. And then, Your Honor, how many time, they usually give windows of times of that you want them to blow into, typically 7 to 9 AM, 11 to 1 PM, 5 to 7 PM, and maybe 9 to 11 PM, you know. He can blow into it several times a day, you know, just to ensure that there's no issue. So if you give me some guidance, Your Honor, I'll make sure that the SoberLink official does it in that respect.
what were the timeframes?
7 AM to 9 AM, 11 AM to 1 PM, 5 PM to 7 PM, and 9 PM to 11 PM. That's 1, 2, 3, that's 4 different times a day. Every day he'll be giving a sample.
And there will be no excuses as it relates to that his job won't allow him to
No,
meet
it's
all
a
those
portable
times.
device like your cell phone, Your Honor.
Oh, SoberLink, okay, that's true. Okay, all right, then the court will set those times that have been noted, the 7 to 9, the 11 to 1, the 5 to 7, the 9 to 11.
Thank you so much, Your Honor.
So we have 4 times. I'm gonna put these times on here. AM, 11 AM to 1 PM. Now, Mr. Hopkins, sir, you understand that you have to follow those timeframes. Your inability to do so will result in your bond being revoked. Is that clear?
Yes, Your Honor, that's no problem. I'll make sure I'm,
Okay,
everything is right.
And as soon as we conclude, Your Honor, I'm gonna call right away, and if he can get it done sooner, we'll get him in there sooner for Your Honor.
okay, just make sure that there's some documentation that's provided.
I will.
Okay, so the court's gonna put on the record 7 AM. Testing 7 AM to 9 AM, 11 AM, 1 PM, 5 PM, 7 PM, and 9 PM to 11 PM, testing times. And a bond will be set at an amount of $25,000 personal. Mr. Hopkins, sir, while you're on bond, you're not to use any controlled substances, and you're to get connected to the SoberLink within 72 hours. You're also not to drive without a valid driver's license. You understand those bond conditions, sir?
Yes, Your Honor.
Okay, then you have a pretrial that's scheduled for March the 26th. And that's gonna be before Judge Jones by Zoom. Is that understood?
Your Honor, I have 4 hearings, March 26th. Is there any way, can we do it in the afternoon at all?
Hold on, Madam Clerk, do we have any flexibility or let him reach out to the court?
Yes, you can reach out to the court.
Okay, so you have to
I'll
reach out to
the
Judge
court,
Jones'
okay.
courtroom and ask for some flexibility with that
Thank you, Your
date.
Honor. And you said
Okay, anything
Judge
further?
Jones, correct?
Yes, that's correct, and that'll
No
be on
worries, Your
March
Honor.
the 26th at 8:30. Anything further, Ms. Douglas?
Nothing from the people, Your Honor.
Okay, anything further, Mr. Bulahanis?
No, Your Honor, and thank you so much. I appreciate it.
Okay, all right, Have a good afternoon.
You too. Thank you.
Okay, thank you. Oh, we have Ms. Carson. Ms. Carson, who do you have?
Yes, sure, I have to walk in.
Mr. Hall? Okay. Okay, so hold on 1 minute. Sir, what's your name? You have to speak up, sir. I can't hear you. Sorry.
I think he's saying Dakari Burke.
Is that what
Yes.
you said? Okay,
Yes.
we're gonna handle a walk-in. If you just bear with the court, we'll be with you shortly, okay? Thank you, Ms. Douglas. Mr. Burke is next. Mr. Hall, we're doing Mr. Hall right now. Did we got the prints? Okay,
Yes,
all
Your
right,
Honor.
okay, thank you. All right, one more. Okay. All right, Mr. Hall, sir, would you state your, I'm sorry, yeah, state your full name for the record?
Clyde Ulysses Hall Jr.
Okay, the court is calling case number 25-0555-1801. The people of the state of Michigan versus Clyde Ulysses Hall. Appearances, please.
Samuel A. Ragnan, Your Honor, for the people.
Good afternoon, Your Honor. Stephanie Carson on behalf of Mr. Hall Jr., 57096. Who waives the formal reading and standing?
Okay, hi, Ms. Carson. Has your client also been advised of his constitutional rights?
Yes, Your Honor, he has.
Okay, then the court will enter not guilty plea on behalf of Mr. Hall. By recommendation, Mr. Ragnar.
Your Honor, the people are going to ask for $25,000 cash surety bond. If you're able to post a bond, we're asked for tether with home arrest. This incident involved something between the defendant and his father. The father initially told the police walking down the street and got shot, and he was shot 3 times in the stomach, which wasn't true. He subsequently told them they got in an argument with the son at the house. His son went in the closet, loaded a gun, and shot him in the stomach 3 times. So, a very dangerous situation, Your Honor. I mean, person to shoot anyone or even pull a gun and point it at him is terrible enough, but to shoot him 3 times in the stomach. He was in critical condition at the hospital, but he subsequently was treated and survived. So we're asking for $25,000 cash surety, tether home arrest. Thank you.
Okay, your response, Ms. Carson?
Your Honor, I'd like to respond. I believe it's actually the stepfather as opposed to the father. I do know that he initially said that nothing happened from my client. I did rip my client out. They never notified me that when this warrant was issued. My client has not had any trouble. There's been no conflict between the people. They don't reside in the same house because I told him until this is definitely over, they can have no contact. But I don't believe that this man wants to proceed. But nevertheless, as slight risk, he's hired an attorney. He's turned himself in twice. He let out on a writ. He did not run. We stayed in contact. He has never been in trouble before. He's self-employed, a lifelong resident, a father. So while I asked the court to impose a personal bond, we don't object to the tether.
Is your client working, Ms. Carson?
He's self-employed. He does retail through the internet. Like he sells items on the internet.
And so that's done from home pretty much?
Yes.
And he resides at a different address than from where his father lives now?
Right. You know, I need to correct one statement I made to the court. While he does conduct most of his transactions online, sometimes he has to meet the people to complete a transaction. It's not all me. It's all me.
Oh, okay, all right. But he's not gonna be able to go to the August location, is that
No,
understood?
he has not, and he will not.
Okay, all right. Mr. Ragnar, you show any priors?
Well, Your Honor,
Prior conviction?
he has a, no, I don't have any prior. I have a previous case, but I don't have results. So nothing further on that.
Okay,
I just want to add, I mean, we get people here that shoot people 3 times and some, everything they're doing now is great and that's well and good, you know, I'm glad they're doing better, whatever the situation is. It doesn't negate what this person, okay? It doesn't exonerate them from what they did. It doesn't, I don't think, give them the right to even be on the street if they're going to shoot someone, and especially a relative. So I'm
I'm not
asking
gonna engage
a cash,
long arguments. about the
excuse me,
difference between
counselor.
Allegations.
Counselor, excuse me. May I finish,
now,
please?
before you interrupt,
I thought you had, it was a while, I apologize.
go ahead, Mr. Wagner. Okay, go ahead and make your point.
Your Honor, I'm just trying to say, Your Honor, that the fact that he wants to shoot someone, I think is a danger, not just to the family, but also to anyone else at all. And I think that he deserves a cash bond and a tether with home arrest. Thank you.
Your Honor, those are allegations, not facts, and this gentleman has given alternate facts as well. So I'd ask the court to look at the totality of the circumstances. And I also need to correct myself. The Auburn address is where my client lives. That the complainant in this matter lives in Harper Woods. Is that correct?
Or each one of them.
I don't,
You live on the Auburn address.
August.
On the August address, that's where my client lives. I believe it's his maternal grandmother's home.
No, my father.
It's your father's mother. So this gentleman, stepfather, has no relation to the August home.
Okay, I see the incident is at McCormick,
Okay.
street on McCormick. So, doesn't look like it's the same location in terms of where he resides. So he's not able to go to the McCormick location though. That'll be clear. Okay, one moment. Make sure I get that down here. Okay, yes, that's here. All right, so the court has heard the arguments of the parties, and it is a very serious offense. There's no question about that. But for some reason, it has taken a substantially long period of time for this matter to come before the court. According to Ms. Carson, that he has appeared twice on this matter in terms of at least trying to resolve it. He has retained counsel and walked in today to attempt to resolve this matter. There are no prior convictions that we show. That does not, negate the fact that these are serious charges, but they are allegations that took place allegedly 12/14/2023, which is well over a year. With that information, it doesn't appear that the parties are living together. And again, he has presented himself to the court for some resolution. So the court is going to set a $75,000 personal bond. Mr. Hall. Or I should ask Ms. Carson. You've indicated that there's been no contact.
No, there's been no contact. I did ask my client that.
Your Honor,
And that's been, one moment, Mr. Ragnar, has that been since 23?
Is that correct? No contact since 23?
No contact.
He said no contact since 23.
So it's the stepfather.
It's his stepfather.
Okay, not that
I
it
met his father.
doesn't mean it's not as serious, but okay, I'm just trying to understand.
Right.
Yes, Mr. Ragnar, you had another comment?
I was just going to add that he says he works from home on the computer, so I don't think a tether with home arrest would be a problem for him if the court deems it appropriate. Thank you.
Okay, I understand your concerns, but Ms. Carson did modify that in indicating that there are times when he does have to deliver packages or goods as it relates to his employment. So the court is not going to impose a tether. You have a $75,000 personal bond. Mr. Hall, sir, you are not to have any contact with Louis Lamont Jackson. No contact means no contact. Directly, indirectly, email, snail mail, nothing. No contact, no text messages. And directly means you doing it, and indirectly means you can't have a third party to have that contact either. So it sounds like it's a familial type relationship that's there. But while this case is pending, you have to follow the conditions of bond as it relates to no contact. And sir, if you fail to follow those conditions, your bond can be revoked and you can be placed in jail. Do you understand that?
Yes, ma'am.
Okay. And while you're on bond, you are not to possess or purchase a firearm or any other dangerous weapon. Again, not to have any contact with Louis Lamont Jackson and not to enter the McCormick location. You have, let's see, 2 court dates, sir. You have a probable cause conference that's scheduled for March the 25th at 8:30. That'll be by Zoom before Judge Jefferson. And then you have the right to a preliminary examination, which is scheduled for April the 1st at 8:30. That'll be in person before Judge Jefferson here in the 36th District Court. Mr. Ragnar, anything further?
Yes, I wanted to apologize to the counselor and to the court for raising my voice. I'm sorry.
Oh, your apologies
It's
accepted.
accepted, Mr. Ragnar, you're always a gentleman.
Really,
You get so heated.
it's kind of unlike me. I don't know what happened there.
You're passionate about what you do. We get it. We understand. So anyway, and thanks for apologizing. We accept it. Okay, so Ms. Carson, you have the court date. You have anything further?
I do. Thank
Okay,
you.
sir, you understand everything? Okay, maintain contact with your lawyer. This concludes this matter.
And Your Honor, it's a pleasure appearing before you.
Yes, always good to see you, Ms. Carson.
Thank you, counsel.
Okay. All right, and so we had someone at DDC. We're back there, DDC. No further walk-ins, right? Okay. Yes, sir. Your name again. I apologize. I forgot.
Dakari Burke.
Oh, yeah. Okay, Mr. Burke.
Yes.
Good afternoon. All right, the court is calling case number. Did they say nothing? Oh, they put it on there, girl. One moment, Mr. Burke. You know what? This is where I write the on my own paper. So give me a minute. I know I'm writing it down, but you need it on your paper. So hold on a moment. Okay. All right, so Mr. Burke, sir. Good afternoon. The court is calling case number 2505641001. The people of the state of Michigan versus Dakaria Devion. Okay, all right, good afternoon. Appearances, please.
Jennifer Douglas for the people, P72748.
Judge Philip Reagan, on behalf of Mr. Burke, waive the reading, stand mute. Good afternoon. He has been advised of his rights, Your Honor.
Oh, just to add on, okay. All right, then the court will enter, hi, Mr. Reagan, and the court will enter a not guilty plea on behalf of Mr. Burke. Ms. Douglas, what's your bond recommendation?
Your Honor, no objection to 5,000 personal. Lena doesn't show any other police contacts. This is a non-assaultive charge, no attempt to flee, so no objection to 5,000 person.
No objection, Judge.
Okay, then the court will set bond in the amount of $5,000 personal. All right, Mr. Burke, sir, while you're on bond, you are not to possess or purchase a firearm or any other dangerous weapon. Is that understood?
Yes.
Okay, then you have 2 court dates you need to remember. You have a probable cause conference that's scheduled for March the 21st at 8:30. That will be before Judge Robbins by Zoom. Then you have the right to a preliminary examination, which is scheduled for March the 28th at 8:30. That will be in person before Judge Taylor in the 36th District Court. So do you understand your court dates?
Yes.
And your bond conditions?
Yes.
Okay, make sure you get your paperwork before you leave the jail so you know when you need to appear, okay?
Okay.
All right, that concludes this matter. Thank you.
Your Honor.
Mr. Are you dates that are going to Yep, you want to right there, send it in.
On Hakeem.
Okay, good afternoon,
No.
Mr. Hakeem. Okay, a moment. All right, the court is calling case number 25-05641101. The people of the state of Michigan versus Devon Vidal Hakeem. Here, please.
Samuel A. Ragnan, Your Honor.
Your Honor, Philip Reagan on behalf of Mr. Hakeem, waive the reading stamp mute. He's been advised of his rights.
Okay, the court will enter not guilty plea on behalf of Mr. Hakeem. Mr. Ragnar, what's your bond recommendation?
Mr. Reagan, you there?
Hey, how you doing, Mr. Reagan?
Better now to see you.
Good to see you. Good to see you.
Got a little
What's your recommendation, Mr. Ragnar?
$5,000 personal bond, Your Honor.
No objection, Judge.
Okay, all right.
No
Then
objection.
the court will set bond in the amount of $5,000. That'll be a personal bond. And Mr. Hakeem, sir, that means you do not have to post any money, but you do need to follow bond conditions. While you're on bond, you're not to possess or purchase a firearm or any other dangerous weapon. You understand that condition?
I do.
Okay, all right, wait one moment for your court date. All right, you have two court dates. Uh-oh, hold on. Is this the right court date? You have a probable cause, a conference that's scheduled for March the 21st at 8:30. That will be before Judge Robbins by Zoom. Then you have the right to a preliminary examination, which is scheduled for March the 28th at 8:30. That will be in person. You understand those court dates and your bond conditions? Okay, all right, then. That concludes this matter. Have a good afternoon. All right, good afternoon, sir. What's your name?
Ralph Smith.
Okay, all right, Mr. Smith. Court is calling case number 25-05-6409-01. The people of the state of Michigan versus Terrell Antonio Jabbar Smith. Appearances, please.
Jennifer Douglas for the people, P 72748.
Philip Reagan on behalf of Mr. Smith, waive the reading stamp mute. He's been advised of his rights, Judge.
Okay, thank you. The court will enter a not guilty plea on behalf of Mr. Smith. Ms. Douglas, what's your recommendation as relates to bond?
Your Honor, the people wouldn't object to 25,000 personal bond. Mr. Smith is not eligible to have ammo. Officers don't indicate they found a firearm in the home. So given that, no objection, 25,000 personal.
No objection, Your Honor.
Okay, then the court will set a $25,000 personal bond for you, Mr. Smith. While you're on bond, sir, you are not to possess or purchase a firearm or any other dangerous weapon, and you're not to possess any ammunition. Is that understood?
No.
Okay, then you have two court dates. Sir, you have probable cause conference that's scheduled for March the 26th at 8:30. That will be by Zoom. Then you have the right to a preliminary examination, which is scheduled for April the 2nd at 8:30. That will be in person. Both of those matters are before Judge Giles. And that's in the 36th District Court. You understand your court dates and your bond conditions? Okay, make sure you get your paperwork before you leave the jail and keep up with your court dates. That concludes this matter.
Would that be also, would that be,
I'm sorry,
would that be also sent through emails?
No, you won't receive an email. You'll get some paperwork before you leave the jail. So you keep up with the paperwork. It'll be, the instructions will be on there as it relates to Zoom. And it'll have your next court dates on there, the one that's in person and the one that's by Zoom, okay?
Yes, sir. All right.
All right. And if you're not able to get on by Zoom, then you come down to the courthouse. But make sure you keep those court dates.
Man, I work evening, so would I have like a grace period?
Grace period for what?
What do you do?
Your
What
court dates are in the morning.
do you
I
mean?
get, and I get off at like 5 a.m.
Okay,
Oh,
next,
No, you don't.
Hey.
Court is at 8:30, sir. So you have to just stay up.
yeah.
You know, unless you call the court and get some instructions to appear later in the morning. But 8:30, that's the only time I could give you. If you need to change that, then you need to have your lawyer reach out to the court.
Yeah,
But 8:30 is your time frame, okay?
that's it.
All right, take care.
So, thank you. Move him out the way.
You're welcome.
Thank you, Judge.
Say your full name. Jovan Hunt.
Okay, good afternoon, Mr. Hunt. All right. Court is calling case number 25-0564-1201. The people of the state of Michigan versus Jovan Dante Hunt. Appearances, please. Is that your case, Ms. Douglas? A Hunt, Jovan.
I was talking to a black screen. I'm sorry. Samuel A. Ragnar.
We're gonna have
Okay.
Mr. Hunt waive the reading stand mute, Your Honor. He has been advised of his right.
Okay, then the court will enter not guilty plea on behalf of Mr. Hunt. Bond recommendation, Mr. Ragnar.
Well, Your Honor, the people are going to ask for a $10,000 cash surety bond with a tether with curfew. And the reason, this is a CCW, they found in his vehicle, Your Honor, but he has a case pending. That is for contributing a controlled substance case that was back on 6/4/24. And when he was arrested on this charge a few days ago, they said there was a warrant out for his arrest on this charge. The charge itself has multiple, I think it has, let's see. He had 89 with him in the car in 1839. So that's the charge that's.
You gotta back up. I missed the
He got a
last.
personal bond. He got a
comment. Okay.
personal bond, so under 765(6)A, I'm asking for a cash bond. We're asking for a 10,000 cash surety tether for the curfew. Thank you.
Okay, so you've indicated that there's a case pending for a controlled
Yes.
substance case that occurred 6/4/24. Do we know what stage of the proceedings that matter is at?
You know, I don't, Your Honor. I'm sorry, I'm not sure.
Okay.
Case, Judge.
You have
know,
a comment,
Mr.
Mr. Reagan?
I didn't know about the case, Your Honor. I didn't know about that case.
Let me see.
I just know it's a CCW right now. It's non-assaultive and I
It
was
is.
asking for a personal bond. That was gonna be my request, Your Honor.
That's okay.
Yeah, but if he's on probation on another matter, then
No.
they're.
I don't think he's been convicted. I think it's
Yeah.
just.
Yeah, he's out of bond, Judge. And
Maybe-
Judge, go ahead, Ms. Ragnar.
I was just gonna say, maybe Mr. Reagan can find out his item status, if he wants.
I don't know about that case.
Well, it might impact how the court rules that if he's on probation or hasn't been concluded. All I have is 6/4/24 and pending. I mean, you show no further disposition.
Yeah, Judge, I don't even know about that case. I don't even think that case is a drug case, Mr. Ragnar?
Okay,
Oh, yeah,
It is a
Judge,
drug
not assault, drug. I thought it was like so drug case, Judge, not assaultive, so I would ask for personal bond. Cause it's
yeah,
not,
it's interesting. I keep hearing about drug cases not being assaultive. In fact, person has 89 pills or something of different flavors. I mean, to me, that's a very serious.
oh, I'm not saying that that's not serious.
I know you're
The
not.
allegations are serious.
Allegations.
He hadn't been convicted anyway.
No
In
one
that
was
case, the court has a CCW currently before it, not the drug case. I was
Correct.
only concerned about the status of the drug case, so I'm
Yeah.
not so
That's
concerned
not
about the
been-
facts
that's
of
not
that.
been convicted, Judge.
All right. My
And
concern
Judge,
was whether or
I
not he
do
was
disagree
on
too,
bond. I
Judge,
was trying
with
to,
that bond, with the, how they interpret that statute about the personal bond, I mean, you can't have a personal bond. I just don't think that applies to every case.
okay, hold on one moment. Okay, I'm looking at 765.6A.
And read it.
Okay, it says, before granting application for bail, a court shall require a cash bond or a surety bond other than the applicant, if the applicant is charged with a crime to have occurred while on bail pursuant to a bond personally executed by him
That's the key,
or
personally executed by him.
has been twice convicted of a felony within the preceding 5 years. So we don't have prong two. Was the bond executed by him? That's what I was trying to find out. Is he's on bond for the other matters?
Post your own
Did anyone
bond?
tell me that?
If somebody else posted bond, I mean, I'm just.
Executed by him, I don't think it's
Or did
being
somebody else
personally
execute?
Question, Mr. Reagan. That's a good point.
That's a great
That's a
point.
good
Did you
point.
post your own bond or did somebody else post a bond for you? Yeah, you, Mr. Hunt. Did somebody else post a bond for you or did you post a bond?
I don't have a bond. What bond?
See, so I didn't know about the case, Judge,
You
at
know
all.
what you're talking about.
You're right, 'cause
Okay.
I didn't know about the case at all.
All right. So it appears that I need some confirmation that that case is in fact pending, because I am gonna
Mr.
set a
Hunt, do you
dollar
have
amount. It's not gonna be
another
10,000. Yeah, they said he's on bond for a controlled substance case.
I'm talking.
Yes, go ahead, Mr. Hunt,
Ah.
please.
Okay, so we're gonna try to get some information on that matter,
Okay.
so that the court can actually make a clear record. And our clerk believes that he was recently arraigned.
Yes.
Okay, all right, what do we have? Yeah, he was before the court yesterday. One moment. Is that you? Let me see. Devon Dante Hunt.
Right.
They don't have the date of birth on here.
It's on here, it's 4:15. It's not already.
Oh, the one on here, let's see. Yes. Okay, same person in, okay. So it looks like, he was here on 3/13 before Magistrate William Burton.
Right.
He gave him a $10,000 personal bond,
He hasn't posted a bond.
but wait a minute, yeah, hold on.
You signed for it. That's all you need to do. You don't need to post anything. You sign your name for it. That fits the statute. I know.
No, it's a personal bond, but this happened 3/12. And then he didn't
Well-
get arraigned till yesterday on a different file and received the bond. So it doesn't look like sequentially that he was on bond.
Well, that may be true.
Because you see what I'm saying?
Yes.
Yeah, 3/13, it wasn't signed till 3/13, so he hadn't even received a bond until yesterday. Okay.
Correct.
That satisfies the court. Court will set $5,000 personal bond.
Thank you,
No, I'm
Judge.
sorry. Wait.
Thank you.
$10,000 personal bond. It'll be consistent with the other matter that's set. $10,000 personal bond. In this case, the CCW case.
Thank you.
Hold on for his conditions. Okay, so Mr. Hunt, sir, while you're on bond, you are not to possess or purchase a firearm or any other dangerous weapon. Is that understood?
Yes, ma'am.
Okay, now, sir, you got two cases, so you have to keep up with your court dates. All right, give me one moment. Because the dates you received today are likely different from the other court dates. Let's see. '21. Okay, so somebody did see that, and you have the same court dates as the other case. All right. So you have a probable cause conference that's scheduled for March the 21st at 8:30. And then you have the right to a preliminary examination, which is scheduled for March the 28th. They have it here at 8:45. So we're gonna schedule that. Hers are at 8:45 if it's a preliminary examination. And that'll be before Judge Taylor. The first one is by Zoom on the 21st, the one on the 28th, that's in person. All right, sir, you understand your bond conditions and your court dates?
Yes, ma'am.
All right, make sure you get your paperwork before you leave the court.
All right, huh?
Okay, he had 10,000 personal bond.
On the back line,
Thanks for that printout, Madam Clerk.
stay the full night. And then Levi Lewis.
Mr. Lewis, good afternoon, sir.
Yes, no.
Okay, sir, because you failed, you have a ticket, and the bench warrant was issued because you failed to appear on that case. Let's see, looks like the bench warrants, let's see. Court's gonna set those bench warrants aside.
Some tickets.
Yeah, all the tickets. All right,
Oh,
to advise you of your rights. Hold on one moment. All right, sir, as it relates to those tickets, you have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, one will be appointed for you. Court is calling case number SP 119110. You are charged with driving an unregistered vehicle, no insurance, and driving while license suspended. For those particular charges, sir, you could face up to 93 days in jail and or receive a fine in the amount of $500. Because they are tickets, the court's gonna set a personal bond for those tickets. You have a pretrial that's scheduled for April the 11th at 8:30. That'll be by Zoom before Judge Williams. Okay, so 4/11, Judge Williams by Zoom. Now we're gonna call your main case. I need you to restate your name for the record.
I ain't Keith Ison Lewis.
Okay. Court is calling case number 25-0563-9901. The people of the state of Michigan versus Damon Keith Isom Lewis.
Daniel
Appearances,
Redmond
please.
for the people, Your Honor.
Blue Record on behalf of Mr. Isom Lewis, Your Honor, we'd waive the reading stamp mute. He's been advised of his rights, Judge.
Okay, then the court will enter a not guilty plea on behalf of Mr. Lewis. By recommendation, Mr. Ragnar.
People are asking for $10,000 personal bond.
No objection, Judge.
Thank you.
Okay, then the court will set $10,000 personal bond. So, Mr. Lewis, that means you don't have to post any money, sir. But while you're on bond, you are not to possess or purchase a firearm or any other dangerous weapon. Is that understood?
No.
Okay, one moment. We say 10,000. That's it. All right, then, Mr. Lewis, sir, you have two additional court dates, because you had those tickets. Then you have a probable cause conference that's scheduled for March 21st at 8:30. That'll be by Zoom before Judge Robbins. Then you have the right to a preliminary examination. That's scheduled for March the 28th at 8:30. That will be in person before Judge Jefferson in the 36th District Court. You understand your court dates?
Yes, ma'am.
Okay, all right. Then make sure you get your paperwork before you leave court. Keep up with the dates you need to appear. Okay, that concludes this matter.
Yes, ma'am.
Thank you.
You're welcome.
Mr. Campbell, say your full name. Michael Williams.
Okay, how you doing, Mr. Williams? One moment. Mr. Reagan, is your office aware that we had an add-on?
Yes, Your Honor.
Okay, all right, that's all I need to know. All right, one moment. Mr. Williams. Okay, Mr. Williams, you have a number of tickets here. I'm gonna address those tickets first. Ms. Douglas. Okay. Because you failed to appear for a pretrial, then there were several bench warrants that were issued. The court's gonna set those bench warrants aside and advise you of your rights. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, one will be appointed for you. Court is calling case number 240563-126-2017. You're charged with no operator's license on person, no insurance, and unregistered motor vehicle. Ticket number SP 1141378, 12/6/2020. Charge of failing to display a valid license. Ticket number SP 1457682, 5323. You're charged with improper plates, unregistered vehicle, and no insurance. Ticket number SP 1457696, 5323. You're charged with driver's license never acquired. Ticket number SP 1504283. You're charged with, let's see, that's 9/26/23. You're charged with driving while license suspended and improper plates. Ticket number SP 675070, 10/13/2017. Charged with driver's license never acquired. Ticket number SP 821176, 12/31/16. You're charged with driving in an unregistered vehicle and driving with the invalid license. Ticket number U992883-13. Date of offense is 5/9/2013. You're charged with loitering in the park after dark, or after the park closes. Ticket number case number 124907661, 6/26/2012. You're charged with driving while license suspended. So for those particular charges, sir, you could face up to 93 days in jail and or receive a fine in the amount of $500. Because they are tickets, the court's going to set a personal bond in those matters. And you have a pretrial that's scheduled for April the 14th at 8:30. That'll be by Zoom before Judge King. 414 for the tickets, okay? Then we're gonna move on to your main case. I need you to restate your name for the record, please. Okay, court is calling case number 2505641301. The people of the state of Michigan versus Michael Deshaun Williams. Appearances, please.
Jennifer Douglas for the people, P72748.
Deliberating on behalf of Michael Williams. Waive the formal reading stamp mute. He's been advised of his rights.
Okay, then the court will enter not guilty plea on behalf of Mr. Williams. Ms. Douglas, what's your bond recommendation?
Your Honor, on Mr. Williams, the people are going to ask for $25,000 personal with the teller to ensure the safety of the complaining witness. While we do acknowledge that this is alleged to have happened at the complainant's residence, there's no indication that the complaining witness was there against his permission. This was somebody who is his on again, off again girlfriend. And when she was leaving, he allegedly became upset and pointed a firearm. We do acknowledge that the report indicates that this firearm was rusty and in disrepair, but Mr. Williams is not supposed to have any firearm. We would note that there was also various shells found at the home, which gives us concern. Mr. Williams was just sentenced January 30th of this year for receiving concealing stolen property, motor vehicle, to 2 years probation. And so he was on probation just over a month when this allegedly happened. He's not supposed to have firearms. So, Your Honor, we do have some concerns for safety of the public. So that's why we're going to go ahead and ask for a tether, but no objection to 25,000 personal if there's a tether.
Okay, your response, Mr. Reagan?
Judge, I thought this happened at Mr. Williams' house allegedly, and the complaint was at another location because the agent came over, they did a search warrant, did a proof of address, said, oh, this is where you live, you can't have ammunition. So I don't think a tether is necessary because he was at his own house allegedly, Judge, when he possessed this, when he did this stuff. But he told me a story. Well, I'm not going to say it here, Judge, but I don't think that he and the complaining witness are going to be talking, or he's not going to be talking to her anymore, Judge. But I'm asking for the personal bond too, like Ms. Douglas. I just said no contact, but I just don't think a tether is necessary because he was at his own house. This was happening in his house. He wasn't going to her house. She don't need.
Okay, Miss.
I'm sorry, Judge.
I'm sorry, Mr. Reagan, I didn't cut you off.
No,
You're
go ahead.
you done?
I'm sorry, Ron.
Okay.
Yes.
I did have a question for Ms. Douglas. I'm looking at the HAB third notice,
Yes, Your
and
Honor.
I see attempt CCW from 15, and then I see is that another CCW from 12/20, or that's for receiving a concealed and stolen property. Is that the one you're indicating he's on probation for?
The ones he's on probation for is listed in the HAB notice, the RCSP motor vehicle. Yes, Your Honor. He was sentenced
Okay,
January
all right.
30th.
Okay. And this was alleged to have occurred on 3/6. How did your client come to be into custody, Mr. Reagan, if you know?
Judge, were you arrested, Mr. Williams, at home, or where were you arrested?
At home, sir.
He was arrested at his house, Judge.
Okay.
They did a search warrant. He was cooperative, Judge. It looked like, he let him in, let him search.
One moment. Do we know, Ms. Douglas, if a PV warrant, probation violation warrant has been issued?
Your Honor, when I looked up the register of actions, I did not see a probation violation warrant yet, but I believe he was just arrested. So I would expect that one would be coming.
Okay. So the court has heard the arguments of the parties. Mr. Reagan, did I inquire if your client was employed or not?
You did not, Judge. He is employed at Ricardo. He makes bus seats. They make those bus seats for the Broncos. They make them by hand where they put the wires in the seats and do different things. So that's where he works.
Okay, in light of the fact that the allegations arose at his location, not sure, what took place, but it was at his house and not her house. And it looks like police report, the police had asked her to leave that location. Then the court is not gonna impose a tether. The court is gonna set bond any amount of $25,000 personal. However, Mr. Williams, sir, please understand that, like, look, you just got sentenced.
Yes, ma'am.
Okay, that's based on a conviction. These are allegations, but they are still serious. So you have to follow your bond conditions, or you are going to end up with your bond being revoked and end up in jail. Is that understood? Okay, and so while you're on bond, you are not to possess or purchase a firearm or any other dangerous weapons, and you're not to have any contact with China Davis. Is that clear? Yeah, no contact means not directly, not indirectly, don't send any messages, text messages, don't send any messages by anybody else. Is that, okay, that's clear then. All right. Then you have, let's see. You have two court dates. You have a probable cause conference that's scheduled for March the 21st at 8:30. That will be by Zoom before Judge Jakay. Then you have the right to a preliminary examination, which is scheduled for March the 27th at 8:30. And that will be in person in the 36th District Court. So you understand those bond conditions and your next court dates. All right. That concludes this matter.
You have a nice day.
You too. Good afternoon, sir. Did we see you this morning? Mr. Bell? Yeah, what was that? We just saw him. Yeah,
Mr. Bell, isn't it?
yeah, we just saw Mr. Bell this morning. Look what was going on this morning.
Mr. Bell, what
He
you
had
doing?
an FA. Is this a different FA?
Yes, Your Honor, it's different.
Okay, I just wanted to be sure. All right, good afternoon, Mr. Bell. The court is calling case number 25-0564-1401. People of the state of Michigan versus David Anderson Bell. Appearances, please.
Jennifer Douglas for the people, P72748.
Philip Reagan on behalf of Mr. Bell, Your Honor, waive the reading, stand mute. He's been advised of his rights.
Okay, then the court will enter a not guilty plea on behalf of Mr. Bell. Ms. Douglas, help the court understand what's going on here.
Okay, so Your Honor, the people are going to ask for a bond of 100,000 cash or surety tethered house arrest. Your Honor, we believe that Mr. Bell poses a grave danger, at the very least, to his uncle, who's the complaining witness in both cases. Now, I know the register of actions is showing the date of offense on this case as being the same as the date of offense on the other case, and that's not accurate. The date of offense for this case is March 12th of 25. The case you arraigned him on this morning, the date of offense was February 24th of 25. And given that we have these two incidents close in time, both involving firearms, we believe shows that Mr. Bell is a danger. Your Honor, just to refresh your recollection, I'm not sure what was said in the morning, but Your Honor, Mr. Bell in the other case where the date of offense from February is accused of shooting at his uncle as his uncle was driving down the road. Officers, one, recovered 3 shell casings, and they also saw indications of the car having been shot with a bullet hole in the front passenger door, a bullet hole in the front right bumper, and then a flat tire front right, which would corroborate what the uncle said, that Mr. Bell was in fact shooting at him while he was in his car. So Your Honor, now we have here in March, Mr. Bell allegedly goes back to the location and is threatening to kill his uncle again. I shouldn't say again, because before he's just supposed to have shot at him and looked at him blankly. This time he's supposed to have threatened to murder him. Mr. Bell was allegedly angry that he was not being allowed to go inside of the house. The complaining witness, his uncle, was trying to take his own mother, the complaining witness's mother, to a dialysis appointment, and Mr. Bell had a firearm in his hand, and then he pulls another one out of his pants. So one is an AR-15 long gun, one is a pistol. Your Honor, officers indicate that they did recover those weapons, but that when they got to the location, that Mr. Bell claimed no one had called 911 and told the police to get off his porch while balling up his fists. Your Honor, we would note that officers had to tase him in order to arrest him. I did send a copy of one of the incident reports to Mr. Reagan. That one had a bit more information. One of the officers indicated that while he was approaching the location, he saw Mr. Bell placing something under the rug on the porch where the police found Mr. Bell standing. And it is just under that rug that police recovered the AR-15 and the firearm. And both of those are registered to Mr. Bell. So that again corroborates this uncle saying that this individual came to the house. Now, I know the report shows them as both living at that house, but the uncle indicates that Mr. Bell moved out some time ago, but that he still gets his mail there, and that Mr. Bell comes over in order to get the mail, but does not live there. And so, Your Honor, we have concern given that one, we have a alleged shooting incident from last month where there's a corroboration of shells recovered and bullet holes in this uncle's car. And then this time we have 2 firearms hidden under a rug on the porch where the defendant is standing, and both of them are registered to the defendant. So at this time, we would also point out that Mr. Bell is also accused of busting out his uncle's windows during this incident, using the butt of one of the guns, busting out 3 different car windows, which the officers were able to see those windows busted out. So when we have someone threatening that they're going to murder someone, having shot at them the month before, we do have concerns that that's exactly what's going to happen. And so that's why I know he got a 50,000 personal this morning. Your Honor, we believe that with this, considering this case, when we look at all these things together, we do think that there's a danger to this complaining witness's life, that this is in fact going to be something where someone could end up dead. Mr. Bell knows exactly where this individual lives because that's where Mr. Bell used to live. And Your Honor, we are asking for a bond of 100,000 cash or surety tether house arrest.
Okay, so before we move on, Ms. Douglas, the date is gonna have to be corrected because I am looking at a file that, let's see. The
Does the
complaint that you have, is it for 224 or 312?
Let me look again. The investigator's report had the right date on it, but let me see if my complaint has the right date on it.
I see on this and it says 224, so we do need to correct that.
You know what? Mine says 224. Whoever typed it wrong because the investigator's report I have has the right date. So that does need to get fixed.
Okay, well, hold on one moment because it's problematic. Hold on one moment, let me see. Okay. We're back on, Mr. Bell's case. Ooh, okay.
Yeah, whenever you get a chance.
Okay, Ms. Douglas, I was trying to follow up and see whether or not, how we could proceed as it relates to those incorrect, dates.
Well, Your Honor, as far as
So-
dates, as far
Yes,
as
go ahead.
dates go, the dates can be fixed at exam. Because at exam, you can have charges added, you can have dates changed. I'm informing the court that it's supposed to be 3/12/25. But I don't believe that this is something that prevents arraignment. A wrong date that would prevent arraignment would be like possibly date of birth or something like that, but not the date of offense. That can be fixed at exam.
Your position, Mr. Reagan?
Disagree, Judge. I want it all dismissed. I just think it's
Not all
inherently
dismissed.
dangerous to try to assume that a date is a certain way. I mean, part of the problem with this is that the prosecutor doesn't want to charge cases when the cases allegedly happen. They want to charge them later on if something else happens. So if this other case doesn't happen, then that first case probably doesn't get charged because they want to charge everything at the same time, different dates, all that other stuff. But regardless, Judge, I don't know what's where. I don't know who's on first. I don't know what's happening with because the dates
So
are off.
let me ask you, Mr. Reagan, were you able to talk to Mr. Bell about the charge that he's being arraigned on this afternoon?
I talked about the 20. I did talk about it, Judge. I did talk about it, but I guess I'm confused now. I know
we're trying to-
we have two gentlemen. We have an uncle and a nephew, probably similar in age, a few years apart, which is a little bit unusual. But I know that Mr. Bell was living at that location because we talked about him going to stay with his dad. He said, I'm gonna go stay with my dad, gave me an address for his dad, so he wouldn't be going back to the Heidelberg. That was one of the things that we talked about. You know, but I kind of looked at these and was confused that when I saw the date of offense and then the incident date, like what's really happening here?
And Your Honor, the problem is backlogged warrants. There are a lot of backlogged warrants. And when there's a new case where the person's in custody, as opposed to a not in custody, then when the in custodies get charged first generally. And so someone has another warrant request sitting there, they'll go and look at that. And so we keep seeing where someone picks up another case and then they're not in custody warrants get charged at the same time, which is what I think led to this typo mistake.
And with all due
Okay.
respect, Judge, that doesn't even. That if the case was sitting there, why wouldn't you just get it? Why do you have to wait till something else to say, oh, let me get that? That just, that's not Miss Douglas. I know that she's just, telling how the process works, but it's ridiculous. It's ridiculous.
Okay, so the court is still gonna follow through with the arraignment, but this is what we're going to do. Because clearly, there's a notification if you have the investigator's report as to the date and the circumstances, the court having sat earlier, and arraigned Mr. Bell on the other matter, the facts in that matter are different from the facts in this case. We just need the date corrected. So, Ms. Douglas, court is requesting that your office submit an amended complaint. If you can you submit it Monday? Your office submit that on Monday with the correct date?
I am putting a note in PBK and I've also notified some supervisors. I am not sure if it's going to be Monday as that's the prosecutor's office and not me, but I am informing them.
Okay, and then can you indicate what the correction would be?
The date of offense would be March 12th, 2025.
Okay. And that's case number 2505641 401, correct?
Yes, Your Honor.
Okay. Mr. Reagan, one moment. Oh, okay, one moment. We have somebody else that can give us an update on this, so hold on a moment. Okay, the court was just trying to get some additional input on how to address that matter. So Ms. Douglas is going to submit or have her office, have the prosecutor's office submit something as soon as possible, preferably Monday, with the corrected complaint warrant. Is that correct, Ms. Douglas?
Yes, Your Honor, I've informed some people at the prosecutor's office, and I will be putting a note in PBK for that to be changed, so that whoever looks at the case next can do that. I'm not in a position to be able to do that with my access to PBK, so I can't do it myself, but I'm letting the prosecutor's office know they need to fix it.
Okay, then as it relates to the location, again, if I'm looking at the report from 3/12/2025, looks like we're talking about the same area, the same location as the offenses from this morning. Is that correct, Ms. Douglas?
That's correct, Your Honor.
And Mr. Reagan, Mr. Bell is going to be residing at a different location, is that correct?
That's correct, Judge, on Tyron, Judge.
I think we've established that this morning. Okay.
Oh.
I don't know if it was you or somebody else that handled it
was
this
me.
morning. Okay. All right, because we talked about the location as well. So, Mr. Bell, sir, I hate to see you back here this afternoon. This morning, you were given a $50,000 personal bond in that matter. However, after the court has heard some additional information, here we have the same complaining witness and another incident where it's a weapon that's involved. The one earlier was a weapon being discharged. Now, whether it was, self-defense or whatever, I don't know. We just have a weapon being discharged in the earlier case. And here we have some arguing that's taking place, and then you get into it with the police, and then weapons are found, allegations of a window being busted. So, sir, I'm not certain what's going on with you and your uncle, but these allegations concern the court. And based upon this additional information, now allegations haven't happened in February, and here we are, not even a month later, with new allegations in the same complaining witness, same area. Sir, I do find that you pose a danger to not only Mr. Melvin Bell, your uncle, but to the community, because once firearms are involved, and a weapon is discharged, that was earlier, but that compounded with this other matter, you pose a danger to the community. So court is going to set bond in the amount of 100,000 cash surety. And Mr. Bell, sir, if you happen to post that bond, then the court is ordering that you be connected to Tether. With house arrest. Mr. Reagan, is that bond affordable or unaffordable?
Unaffordable, Judge.
Okay. Then there'll be a bond redetermination hearing that's scheduled for Monday, March the 17th at 9 o'clock. That will be before Judge McConaughey or Judge Williams. Mr. Bell, as the court indicated earlier, you are not to have any contact with Melvin Bell and you're not to possess or purchase a firearm or any other dangerous weapon. And you are not to enter the Heidelberg location. Or go to the Heidelberg location. One moment, write that in here. Enter. Okay, so Mr. Bell, on this file, you have two court dates, sir. You have a probable cause conference that's scheduled for February the 25th at 8:30. That'll be by Zoom. I'm sorry, March 25th. I'm back into the month of all the stuff. March 25th at 8:30. That'll be by Zoom before Judge Jefferson. And then you have the right to a preliminary examination, which is scheduled for April the 1st at 8:30. That'll be in person before Judge Jefferson. So, Mr. Bell, sir, you understand your court dates and your bond conditions? Okay, all right, then, I guess I didn't ask Mr. Reagan, sir, that bond that was set, is that affordable or unaffordable?
That's unaffordable, Your Honor.
Okay, then a bond redetermination hearing is scheduled for, again, Monday at 3:17 before Judge McConicle or Judge Williams at 9 o'clock. Okay, that concludes this matter.
Thank you, Your Honor.
Okay. Thank you. Oh, right on here that an amended complaint is forthcoming, if you would.
Okay.
Okay, or do you need me to write it on there? That was on Mr. Bell.
Yeah.
It's 3/12/25 is the correct date. Yes, I can. I just want to make sure that they know somehow. Okay, see if that's sufficient. Okay, sir, at DDC, what's your name?
Young.
Ray Young, okay, thank you. This is the add-on. Mr. Reagan, did your office have an opportunity to talk to Mr. Young? You're on mute.
I'm sorry, Judge. Yeah, we ready on Mr. Young, Your Honor. We did speak to Mr. Young.
Okay. All right, then the court is calling case number 25-05641801. The people of the state of Michigan versus Ray Young. I need your appearances, please.
Jennifer Douglas for the people, P 72748.
Your Honor, Reagan appearing on behalf of Mr. Ray Young, waive the formal reading, stand mute. He's been advised of his rights, Judge.
Okay, then the court will enter a not guilty plea on behalf of Mr. Young. Ms. Douglas, your bond recommendation.
Your Honor, the people are asking for a remand pursuant to MCR 6.106B1B, as Mr. Young is charged with CSC first degree twice. So he's eligible for remand twice over. Your Honor, here we have an allegation of Mr. Young sexually assaulting one of his grandchildren for years, starting with inappropriate touching, and then transitioning to having intercourse with this child at the age of 12, and that continuing for the last 4 years, Your Honor. So here we have concerns that this has gone on for alleged 8 years, and so we do have concerns for the safety, not just of this complaining witness, but of any youth that Mr. Young may be near. These incidents are supposed to have happened at the home he shared with the child. And so, Your Honor, a personal bond with tether house arrest by itself is not sufficient to protect the public or this child, who apparently also stays at the location, but also the court does not have a way to make people aware that Mr. Young is not supposed to have any children at his house, Your Honor. And so we're asking for a remand in order to protect the public and any child that Mr. Young may have access to. This alleged abuse is supposed to have started at when the child was 8 and continued for 8 years. So, Your Honor, this isn't some sort of one-time thing, which would be bad enough, but it seems to be a method of living for Mr. Young, according to the allegations. And so we are asking for a remand in this matter.
Your response, Mr. Reagan?
Judge, Mr. Young's 70. Judge, he's still doing some heating and cooling work and electrical work. He's been doing it for over 40 years. He also gets Social Security. He's kind of semi-retired, lives with his wife in the city. Obviously, he's to have no contact with any minor children. We're asking for some type of nominal bond, Judge, other than a remand in this matter.
Ms. Douglas, does Mr. Young have any priors?
Your Honor, I do not see any priors. However, I think in the case of sexual assault of a child, that is not as relevant. It is common for sexual assaults not to be reported. Here we have the child saying that she had not told her mother because she thought that Mr. Young was going to hurt her. And so, Your Honor, it's common for these things not to be reported. He does not have priors, but given that this is supposed to have happened for the last 8 years, we believe that remand is the only thing that can ensure the safety of the public.
Okay, I wasn't just referring to a sexual assault. I was just asking about any priors, period. So
No, Your Honor, there's no priors.
At times. Okay.
All
right.
Monetary bond is what I would be asking.
I'm sorry, Ms. Reagan, I didn't hear you.
Judge, I'm sorry. I was saying a monetary bond is what I would be asking for to the remand.
Okay. So these the facts here are very alarming to the court, as again, they are allegations. However, based upon the investigator's report, it appears that, first of all, the complaining witness in this matter was a grandchild, and that she was very young at the time these allegations arose. The dates on the actual complaint indicate 2/18/2016 to 2/18/2025, and over that period of time, that there were allegations of sexual contact. Initially starting with touching and then becoming more serious as it relates to the allegations that lead to count 1, criminal sexual conduct, first degree. Person under 13, defendant 17 years or older, and then that's 1 and 2, as well as counts 3 and 4 deal with the relationship, but still with the child who was at least 13 but less than 16. And based upon how far it goes back, I'm not sure if that's written correctly as relates to those charges, but that's what's identified here. It's still a minor, whether it's under 13 or 13 to 16. And so the fact that you've been employed for 40 years, that's commendable, but based upon the allegations that are currently before the court finds that you are a danger to the community. And because of the length of time and the escalation as it relates to what was taking place or alleged to have been taking place with this young complaining witness, then the court, finds that oh, wait a minute, 1 minute, let me check something else. Oh, there's also allegations, even though there are only 4 counts here, the investigators report indicates that this is something that may have taken place on multiple occasions, from ages 8 to 16. So, and it was indicated that, based upon her interview, she's indicating that, it was disclosed several different times that, Mr. Young had sexually assaulted her. Also, it looks here like there were several admissions that, were made as well when he was interviewed by, Detective Brent at, DDC. So with that, the court does find that the presumption of, is great. And the court, is going to remand Mr. Young. So I need some different paperwork. Okay. Sir, your next court dates, you have a probable cause conference that's scheduled for March the 21st. That will be by Zoom before Judge Jakay. Then you have the right to a preliminary examination, which is scheduled for March the 27th at 1:45 p.m. Now, your matter on the 21st is 8:30 by Zoom, but your preliminary exam is in person on 3/27 at 1:45 p.m. That's also before Judge Jakay. You understand your court date, sir?
Understand the dates.
Okay. So, outside of that, unless there's anything further from you, Ms. Douglas.
Nothing from the
and
people,
Mr.
Your Honor.
Reagan. Mr. Reagan?
Nothing further, Judge.
Okay, and that concludes this matter. All right. Okay, Mr. Young, sir, have a good day. Yeah, I need the right paperwork. Okay, thank you.
Your Honor, we're gonna meet you on the female side.
Oh, okay. I didn't realize we got there. Okay, thanks so much.
All right.
Oh, it says female sign. Okay. Okay, all right. I'll be on a brief break. Oh, they got them already. No, we're not taking a break. Okay. You rocking and rolling. All right, ma'am. Good afternoon. Can you state your name for the record, please? Oh, they have you on mute. DDC female side is on mute.
Bianca Rebels, ma'am.
Okay, good afternoon. All right. Okay, the court is calling case number 25044748001. The people of the state of Michigan versus Bianca Louise Rebels. May I have your appearances, please?
Jennifer Douglas for the people, P72748.
We'll bring it on behalf of Ms. Rebels, Your Honor, and waive the reading, stand mute. She's been advised of her rights.
Okay, then the court will enter not guilty plea on behalf of Ms. Rebels. My recommendation, Ms. Douglas.
Your Honor, for Ms. Rebels, the people wouldn't object to a $25,000 personal bond, but we are asking for an alcohol tether. While I know this is not a driving case, we would note that Ms. Rebels had actually been at the location just the day before the charged incident when the complaining witness had called the police because Ms. Rebels would not leave. Ms. Rebels was told by police not to come back, in addition to the complaining witness telling her not to come back, and she was taken to the hospital. Apparently, she had drunk so much that she could not or at least she said she couldn't remember the next day. She had been told not to come back and went back to the location and went through the window. So, Your Honor, the people have the concern of Ms. Revels becoming intoxicated and not remembering what she is and is not supposed to be doing in the future. And so that is why we're going to go ahead and ask for that alcohol tether to ensure that she's able to follow the rules that the court sets for her, seeing as how when she is intoxicated, she apparently has trouble remembering things. So that's what we're asking for, 25,000 personal with the alcohol tether.
All right, Mr. Reagan, your response, please.
Judge, Judge, she was living at the place with the complaint. They were living together. That was her house. So I mean, drinking you should never drink excessively. I agree. I don't know what circumstances were, but she's gonna go stay with her parents. Just she's leaving. She has a child. He has 4 kids. They had I think a total of 5 altogether. But she's gonna go stay with her parents, and she's she's not gonna get back together with him as though she says, Judge. So no contact. It's a misdemeanor case, Judge. I'm confident, Judge, that she will not have contact with him based on what she told me in the interview, Your Honor. So I'm just asking. I don't think the alcohol tether is necessary. If the court wanted to put a no drinking condition as to bond, I mean that, the court, can do that, Judge. But I don't think alcohol tether is necessary.
Your Honor, we would note that the
Okay.
complaining witness says she did not live there, and that police indicate in the report that Miss Reed Revels herself said that she had just flown in from Las Vegas a few days earlier, and that's what the complaining witness says. He says that he was only letting her stay there for a while until she could go someplace else, and that she had only been there a few days. And so, Your Honor, with her just being there for a few days, and also being told by both the complaining witness and the police that she wasn't supposed to return, that's why we have that concern.
Judge, she didn't tell them. She never
Okay.
told the police that, but she did live there. He's not telling the truth, as some people don't tell the truth. But it all come out later, Judge, in the case.
Okay, so I'm just trying to be clear. The location is on Montrose, and she does not stay at that location as far as where the incident is alleged to have occurred.
Yeah, she was living there. He just says what he wants to get her out, but and that doesn't work that way. But I guess she's got a case now, so she can't go back. So and she doesn't really want to go back. She put a case on people.
Okay, they do have an address that's listed on here somewhere on Shaftesbury. Is that where she's going to be staying?
That's the parents' house, Judge.
Okay. As long as she doesn't go back to the Montrose location. All right, so the court is going to set